Hello, everyone, and welcome to Debrief, the Napthans Legal podcast. My name is Keith Melling, and I'm the head of corporate at Napthans.
And I'm Helen Lucking, and I'm the head of family at Napthans.
So, we're here today to talk about shareholder advice in the context of families expanding and contracting. And it's fair to say, Helen, that doing what we do day to day, our paths don't often cross.
They don't, Keith, no.
I'm typically working with business owners putting together shareholder agreements. And this is one exception that proves the rule, I guess, because we often get asked the question when people are putting shareholder agreements in place and making arrangements to transfer shares. Well, what are the implications of changes to family status to those relationships? And I'll often be asked by a client, okay, I'm in business, there's myself and a business partner, we're both married. If my business partner gets divorced, do I run the risk that his shares could end up in the hands of his spouse, and therefore I find myself running a business with someone I don't know? Alternatively, if my wife has shares, I'm in business with her, and we get divorced, you know, what happens to the shares in that
Mm.
scenario? Can we write an agreement that says that if we get divorced, one person's got to transfer the shares to the other? So these are typical, I suppose, worries that clients have. And I think it's worthwhile starting, Helen, with maybe answering the question, what happens to shares in the event of a divorce?
Yes, thank you, Keith. In the event of a divorce, shares are treated in exactly the same way as any other asset that the couple have. Even if they're in the name of, say, the husband, they would still be treated as a matrimonial asset, an asset of the marriage, and they would need to be valued. And usually you would get an independent forensic accountant to value the shares and then to provide a value of the whole, usually of the whole company, and then of the percentage that the person, the client has. And then that would be added to the other assets in the case. And the parties and their solicitors and ultimately the court would then look at, well, that's the asset pot. How are we going to divide it? And sometimes shares can be the biggest asset
Hmm.
in the marriage. So it's a question then of how do we divide that fairly between the parties?
Right, I see. And before we go any further, I'm conscious that I'm talking about marriage and divorce. Are the rules different? Are there similar rules which apply in the case of cohabitees who may be in a 20-year-long relationship, but they've never been married?
That's a very good point because the law in relation to cohabitees is completely different. So that if you are not married and you're, say, a man owning some shares, but if you're not married, then your partner would not be entitled to a share of your shares in the company in the business, whereas they would be if you were married. So it's a very clear distinction there, and it's worthwhile people knowing about that.
Yeah, no, that makes sense. So, I suppose to answer the question I posed at the outset, the concern from the client is I'm a shareholder, my business partner's sat alongside me, he's going through a divorce. Um, would the court order that his shares upon a divorce be transferred to his wife, with whom I've never been in business before, I've never even met her? I wouldn't want to be in business with someone I don't know.
That's a common concern, but happily, the court is not in the habit of transferring shares to a different third party who, as you say, has no expertise in running a business and would end up potentially being a hostile shareholder with potential voting rights in the business that could really destroy the business and its future. So that it isn't something that the court does as a general rule. I think if there were no other option available, then the court might, but that's very rare. The only exception I can think of where the court might transfer shares to a party is if the business was about to be sold and they knew it was about to be sold and they were concerned that if that person wasn't made a shareholder in the business they wouldn't get any money.
Hmm.
But again, I think the court would be wanting to more likely make an order that the shareholder, if he sold his shares, gave his wife a percentage.
Hmm.
That would be much more likely because the court really doesn't want to put somebody who isn't a business person or doesn't want to be in the business into that business as a shareholder.
Okay. So When I'm advising a client, typically, I'll be putting in place a legal agreement, a shareholder agreement, which is a private document governing the rights of the parties as regards their shareholding. So it will deal with matters such as the right to control decision making, the rights to receive dividends, and also either within the articles of association, which every private company
Mm?
has to have, or within the shareholder agreement. There'll be something around what happens in certain events, such as death, incapacity, leaving the business, and so on. So I'll often be asked by a client, well, can I just write something in the shareholder agreement just to be absolutely clear that if the court's got this discretion that could possibly, in a very unlikely scenario, involve my co-shareholder having to transfer his shares to his wife, or to address the fact that he doesn't want the shares to actually have any value as far as the marital pot's concerned. In other words, the spouse shouldn't be entitled to any value coming out of them. Is the shareholder agreement the right place to put a provision which stays that?
I think it helps, but I think it also helps more if you have a document, a marital agreement. You will have heard of prenuptial agreements or postnuptial agreements. Those documents, coupled with a shareholder agreement, to say something like the person wouldn't be entitled to those shares, would should they divorce, that would be better and would be more helpful. It's marital agreements are something that we are finding we're putting in place more and more often to help people in business negotiate their financial planning and their affairs generally.
Right. Okay, let me stop you there. So the shareholder agreement, private document between shareholders, the court, if they wanted to, could say, well, that's all very interesting, and it may be an indication of the parties' intentions, but actually what we want to see is a document between the spouses rather than a document between a spouse and a business partner.
Yes.
So just talk us through a little bit around how the prenuptial agreements or these marital agreements work.
Okay, so a pre or a postnup, as they're more commonly known, is a contract made between spouses, which essentially sets out what the financial settlement would be should you get divorced. So at the start of your relationship, you're potentially saying, if we do get divorced, this is what will happen. But within those agreements, you can set out, say something like the shares in my family company that I already own will never be a marital asset. They will never be part of the assets that are going to be shared with the wife or the husband. And those agreements need to be, it's a contract. So they have to be signed after both parties have taken independent legal advice. They cannot be signed under duress. They have to be clear in their terms and they have to be fair and reasonable. So, what you can't do in a marital agreement is say, I'll keep everything, you get nothing.
Right.
That's not fair.
Mhm.
So, it has to be fair. The court in matrimonial proceedings is always based on everything being fair and reasonable. So, the court would still value all of the assets to make sure that the marital agreement is in itself fair and reasonable, and but if it is fair and reasonable, then there is no reason why the court wouldn't say yes, that's fine,
Right.
you go along with that agreement.
Yeah.
So marital agreements are not in themselves legally enforceable, but they are one of the things that the court does take into account in all the circumstances of the case. And as I say, if they're fair and reasonable, it's more likely than not that the court would uphold them.
Right. And is there a distinction between a scenario where a husband and wife enter into a prenuptial agreement before the marriage with regard to what's going to happen to an asset versus a situation, say, 20 years down the road where they've been married for 20 years, the shares are much more valuable than they were at the outset. And at that point, one of the parties, let's say the husband's the shareholder, says, I'd like to sign a post-nuptial agreement. Is that at risk of being less enforceable because it's post-nup rather
it,
than prenup?
it's at risk of being less enforceable because you've got a 20-year marriage, and at a period of a 20-year marriage the court would be expecting you to share everything really equally between you, and if at that point you're suddenly trying to ring fence shares which could be the most valuable asset of the marriage, you're in danger of a court not accepting that agreement. But it does depend entirely on the individual's or the couple's circumstances,
Yeah,
because it might be that there are other assets which could compensate, say, if the wife, if she took those and the husband kept the shares. So it does depend on the individual circumstances. But I've done quite a few nuptial agreements recently where you're trying to ring fence assets which would go down the family line. So whether that's shareholdings in a business, or whether it's sometimes farming assets.
right.
And that's happened. It's been more common and been an issue on people's minds since the budget of October 2024.
Hmm. Right, I see. And I think when you're right when you say that, because I think that's something we're coming across much more with the changes
Yeah.
to inheritance tax, the limit of £1 million business property relief now, rather than treating private limited company shares as being not subject to inheritance tax. Um, there's a real push, I think, now amongst shareholders to try and make the most of that £1 million
Yeah.
per head. So if you take the example of an individual shareholder might own the whole of the company, he might now want to decide he wants to push some of his shares to his wife, push some of his shares to his daughter, some to his son. And I guess the concern is, as I see it, not so much around maybe giving shares to his wife after a marriage of like 20, 30 years, but the concern about the next
Yeah.
generation and the concern around, well, what's going to happen if I put a decent amount of value into in the company in the hands of someone who's relatively young, who might meet the wrong person?
Yes.
How do we deal
Absolutely.
with that? And that feels like an area where this is going to be really important.
Absolutely. That's the area where you would be wanting to do, if you're going to get married, you would want to do a prenuptial agreement, and that would really be most advisable in that circumstance.
Yeah.
Or you don't get married.
Exactly. And I think part of this isn't just the legal advice, is it? It's almost the handling the emotional situation of having the conversation with a family member to say,
Mm.
"Look, these are legacy assets. We might be the third or fourth generation. These shares, no matter what happens, will never form part of your marital pot." And making sure that's understood at the outset.
Absolutely, that is quite a difficult conversation to have. And I had a prenuptial agreement, a postnuptial agreement that I drafted just before the October 2024 budget, where I got some shares going down the maternal line, and they were third generation shares, and it was the husband who had to accept that those shares were going to their daughter and would not be going to him. So it's something that we do and we draft, but as
Mm,
you say, difficult conversation. And I've had other clients who are finding that they're having to have that, and it is quite a tricky conversation. Perhaps it's the person who owns the shares currently, so the father and mother who are saying to their children, as you say, to their adult children, an adult children's fiance, I'm terribly sorry, this is really awkward, but you really need to go and take independent
mm,
legal advice about this. But it's very important, because without the independent legal advice, it isn't going to be a valid
right.
prenuptial agreement.
Right. Okay. So I think from today's conversation that the key takeaways I'd say are, first of all, asking clients to consider very carefully if they're going to move shares around, where those shares may end up. If they have got concerns on the shares ending up somewhere they oughtn't to,
Mm,
and the risk around losing value or taking value out of the family, consider carefully the benefits of a marital agreement.
definitely.
And if you want to put in place a shareholder agreement to deal with this sort of thing, you certainly can do that, but be warned that the prenup, postnup is probably the better route to deliver the solution you're looking for.
Yes, absolutely. That's right.
Okay. Well, that's been really helpful, Helen. Thanks a lot for your time and for talking that through with us. And we'll see you all again soon.
Lovely. Thank you.